Hello, and thanks for joining us. I'm Jeff Kanige, the editor of NJBIZ, and I'll be your moderator for today's panel discussion on immigration and employment law. We'll get to that in just a moment, but before we do, there are a couple of things you should know. First, we're going to leave time for some questions. If you want to pose a question to our experts, just click on the Q&A button in the Zoom control bar, enter your question, and we'll get to as many as we can. Now, it's best if you don't ask anonymously. That way we can get you an answer via email if we run out of time in the program. And we do expect some questions, so if you really want an answer, don't ask anonymously. Your fellow participants won't see your name. We will, but they won't, so your anonymity will be protected in that way. Now, some of you submitted questions when you registered. We have those, and again, we'll get to as many as we can. Finally, today's discussion is being recorded, and you'll get a link to that recording via email within the next day or so. All right, let's get going. It is my great pleasure to welcome our panel for today, and once they are all gathered here virtually, I'll ask them to introduce themselves. Panelists, if you'll join me on screen. Excellent, very good. I guess we'll go alphabetically, and I'll ask Leonard to start off.
Thanks, Jeff. So good afternoon, everyone. My name is Leonard Dorigo. I'm the Immigration Practice Group Leader at Harris Beach Murtha with offices throughout the Northeast. My practice is primarily focused on employment-based immigration, representing employers in all industries and securing highly skilled foreign labor.
Thank you. And Min?
Good afternoon, everyone. My name is Min Kim. I'm a partner and immigration attorney at Chugh LLP. We have 8 offices across the U.S., mostly concentrated in the East and the Western coast. I've been practicing exclusively business immigration law for about 15 years now, and my area of expertise is mapping out, I would say, immigration strategies and helping businesses with their strategic workforce planning, as well as representing my clients in certain compliance work.
Excellent. And Patrick?
Good afternoon. Pat McGovern here at the Genova Burns Law Firm in Newark. I've been practicing in the immigration law space since 1980. When I first started practicing in New York, then I went in-house with Allied Corp, which became Allied Signal, and then Honeywell International, which supported the expat services. A lot of folks coming into the United States from Europe and Pacific Rim. Returned to the law practice at Genova Burns and found that there's a demand for immigration law. And so at this time, much like my fellow panelists, our accent and emphasis is on business visas, assisting management with non-immigrant visas, and the H, the K, that's the fiance, the L, intercompany transferee, the O, non-immigrant extraordinary ability, E, treaty trader, P, occasionally an entertainer coming into the United States. Those categories, and with immigrant visas in higher education, healthcare, technology industries, and occasionally with naturalization petitions as management is supporting some of its employees with respect to obtaining citizenship. Good to be with you today.
Thank you. Great to have you. Great to have all of our panelists. The reason we're here is that there's a lot been going on in this area over the past few months, and I wanted to get a sense for exactly where things stand. And to do that, first of all, I'm going to ask each of you to tell me a little bit about what you were expecting with the election, the second election of Donald Trump. I mean, in his 3 campaigns for president, he made no secret of his views about immigration. Not a big fan. So I'm curious if there's anything that surprised you, or if it's pretty much gone the way you expected, and then we'll get into exactly what's happened. Why don't I start with Min and tell me a little bit about what you were thinking since the November election, and what you were anticipating, and whether that's all panned out.
Right, absolutely. So I mean, I suppose. Practitioners within our space, we typically refer to, the first term of President Trump as Trump 1.0, and Trump 1.0, a lot of it was kind of marked by policy making through adjudication. I want to say, there were attempts on the part of the administration, 4 years back to, kind of change the regulatory agenda. Kind of create new rules that are, definitely anti-immigration. But a lot of times those attempts were met with court challenges, and it really didn't go anywhere. And so I suppose, one thing that the administration did so many years back, and it appears they're now kind of kind of re-upping this time around is to create policy based upon adjudication, meaning that, whether it be denials of, certain cases, such as an O1 petition for extraordinary ability, EB1A, similar for extraordinary ability individuals, just a lot of, rejections and denials. Let's say even for something as common as a blanket L1 for, for a multinational manager, for, for a global organization. A lot of those cases that have been relatively straightforward, they've been met with a lot of resistance at the State Department level for a visa application, at the border with CBP. And it just seems that we're kind of back in the same climate, unfortunately, that we were 4+ years back. And I suppose maybe one thing to to kind of add to that is that, in addition to this stigma regarding lawful immigration, there's been like a perpetuation of fear. I want to say by the administration this time around. Granted, the world right now is a different place than it was 4 years back when we were kind of in the midst of COVID-19 and everything of that sort. But still, it seems like the administration is kind of leaning into that fear agenda once more, and pretty much kind of bullying foreign nationals with misinformation, kind of forcing them out. And I suppose just a recent thing that a lot of people that's kind of in the news is for the encouragement to self-deport. So if a foreign national thinks that he or she is here in a precarious situation, the administration is kind of forcing them out with the option to self-deport. So that's been concerning.
Okay. Right, indeed. And Patrick, I mean, as Min suggests, we got a sort of a taste of this in the first Trump administration, and it seems like I remember we had a panel discussion about what to expect in the Trump administration back in January or February, and one of the feelings on the panel was that, yes, Trump at 1.0, as Min put it, was sort of a trial run. This time, he's much more prepared, and some of the people that he's put in place are more prepared to carry out the kind of agenda that he's been talking about. I'll ask you the same sort of question then. What are you seeing, or is what you're seeing what you expected?
I think the Carole King lyric, I feel the earth move under my feet, sums it all up. Yeah, very much better prepared this time around. Look, he's got his attorney general behind him, and in my opinion, it's just my opinion, I think she'll say anything and she'll sign anything. It's just they go into court trying to defend these executive orders, and the judges tongue lash them, and they were ready on January 20 in 2021 to sign the executive orders, but as far as marshaling their troops to be able to have legal arguments that will convince the judiciary to confirm some of these extraordinary and extreme positions, birthright citizenship being just one of them, they're just not ready, and it reflects so poorly on the legal profession that these folks go in, and these attorneys are then mulched by the U.S. District Court judges. And so you go through all the various executive orders, birthright citizenship, refugee admissions, catch and release, immigrant registration, the invocation of the Alien Enemies Act. It's just unprepared. It's a train going down the tracks with no locomotive engineer in charge. And I think that was the strategy. How much can we throw at the American public to make sure that they can't handle it all? And in my opinion, it's with some gratitude we see there are agencies and there are foundations that are standing up to this particular administration. It's really the non-predictability, as Min pointed out. It's the fear. I see it as intimidation, and you see it in how Harvard is being treated. University clients don't want to be treated that way. They don't want to kind of stand out and lose the ability to attract international students. Why? The tuition. They need the tuition in order to survive. So they're not willing to stick their heads out. But then you see some of these high-powered law firms are willing to stick their heads out, and they're successful. I'm sure making the Paul Weisses of the world regret the fact that they kowtowed. But anyway, I think it's a situation that will continue. The president thinks that he's made this promise to the American public, and of course the continuity is Stephen Miller, who's the boy genius on the immigration strategy, and he's still with the administration. So I think we're just going to see more of this extreme pushing the boundaries of the law and a lot of litigation. And I think we'll get into the litigation, but let me
Yes.
turn it over to my fellow
Yes.
panelists now.
Yes. Okay, Leonard. And as Patrick mentioned, I mean, there's been sort of, and the administration seemed to make a concerted effort to sort of just turn on a fire hose of this kind of stuff on January 20th and in the days following. Again, is that the kind of thing you were expecting? I mean, they pretty much telegraphed that that's what it was. That's what they were going to do. But were you surprised at all by the intensity and by the sheer volume of policy changes that came out?
Yeah, so the nice thing is we have the lens of 2016 to look at. So we saw what the agenda was. We saw the very subtle changes that they made, not by changing the law, but through executive action, which really had significant impacts on legal immigration. And we're talking about just small little things that happen overnight. One of the things that, we used to do every morning, which we're doing now, is seeing what changed overnight, whether it's a filing address, whether it's a fee, whether it's, an interpretation of policy or guidance that's changed overnight. Something's usually changed. So we became very good at pivoting. And coming and at the last minute finding new solutions for clients. But I do feel like there's a level of intensity that I don't know that we could have imagined. We lived through it before, and so we were thinking, we know what to expect. It's the same old game. But there is a different level of intensity this time around. And so that's the scary part of it. And a lot of it is nonsense. And a lot of it is, a ruling by executive action, and the courts are going to step in and overturn or reject this. But it creates havoc and fear. And sort of that's the dangerous part of all of this is when you're ruling from that perspective, it's creating fear with employers and employees and foreign nationals in general. And the other thing that we have this time around is Project 2025, even though the administration denies it altogether. You can look, point by point, and that's really what the agenda is. And one of the items in that proposal is to reduce legal immigration by 50%. So there's a lot of media coverage on the migrants and those that are in, have criminal orders and orders of deportation against them. But there's a whole other side of this, and that's legal immigration. And people don't realize that that's what's under attack just as much as illegal immigration.
That's a good point, and I meant to mention that was because the president and some of the people he put in are they really hate illegal immigration, and they're not too fond of legal immigration too. Just before we move on to sort of trying to unpack a lot of what's been going on, I do want to get a sense though from each of you about what you were hearing from your clients in the lead up to January 20th. Were they saying the same sorts of things? Were they worried? Were they concerned? What was the attitudes of the people you work with generally? Patrick, you're nodding, so I'm assuming you heard something.
Oh yeah, no question about it. It's with all the applications pending, and then of course the end of the year, the holidays are coming in December of 2024. The clients are saying, okay, well, this particular beneficiary applicant wants to travel home to the home country. What do you think? And because obviously by now Trump's been elected, and then of course the answer is, are they going to be home before January 20? And that's going to really enter into my advice as far as whether it's safe to travel.
Okay.
And oh yeah, so that was the big issue. Can these people travel? Because the anticipated that the entire approach coming through Customs and Border Protection and any other checkpoint was going to change as of January 2021, and of course they were correct.
Okay. Leonard and Min, were you hearing the same sorts of things? I'll start with Min.
Travel
Leonard.
is always a concern, but also, there were a lot of stories. We knew what was going to happen on day one. We knew what the targets were. So employers were basically scrambling. A lot of my clients, are we going to be able to bring in workers? So I have a large seasonal visa practice, which is H-2A and H-2B. And so we have landscape companies, we have farms, hospitality that have to plan on getting labor every season. And if those workers don't arrive on time, then it cripples the business. So we heard a lot of fear and concern whether, workers were going to be able to come in for the season, which these seasonal businesses rely on. The other thing was people that were on, humanitarian parole, TPS. That was a target early on before January that, were these statuses going to go away? So what we were counseling our employers on was to identify any employee that's in a vulnerable status. So that's going to be, DACA, that's going to be TPS, and find, and figure out, solutions to backfill those positions, because they can't do without these employees. But the status is insecure, and they didn't know whether they were immediately going to end parole status for these individuals or not. So there was widespread fear in that area as well.
Okay. And Min, let me just let you weigh in on
Right.
that, what you were hearing and what's been borne out.
Right. I would agree with with Leonard and Patrick there regarding, I suppose like the apprehension that practitioners, folks within my office, along with all the employer and the employee clients that we represent in the immigration space. We were waiting with bated breath, and we know that it was going to be, fairly rocky with the, the promulgation of proposed regs and those executive orders on January 20th. But I suppose just to kind of approach it from a different angle, there are still some surprises as well. I mean, we were expecting the worst, but I don't know. Perhaps Leonard and Patrick might disagree with me, but just the focus on F1 students, especially. Like, I understand that a lot of the attendees are from businesses and employers, but when it comes to like the track of a foreign national, hiring foreign nationals and joining a U.S. organization, a lot of the recruitment starts at the student level. Kind of students, enrolling in universities, gaining work authorization pursuant to the practical training, and then making a career out of out of their field of expertise. And it just seems like the F1 student population has been under attack. I mean, Patrick, kind of referenced it earlier with everything that's going on with Harvard, but on a broader scale as well. There was that entire episode. It definitely took me by surprise when when ICE was terminating all the SEVIS records. And granted, the courts got involved, and thankfully, there was some resolution towards the end. But I do know that a couple of my clients, because of that fear and just the thought of the unknown of like am I going to be able to remain lawfully here and continue to be work authorized, they chose to self-deport. And that self-deporting decision was a lot of time encouraged by the misinformation by this this current administration was kind of pushing out there. The misinformation of like, it's easy for you to come back in, come out of the shadows, go back home, and then, you can secure another visa. Well, the thing is, like, depending upon someone's context and their background, it might be virtually impossible. They might be subject to certain 10-year bars if they accrued, certain unlawful presence. So the fact that the administration was kind of pushing out the agenda of trying to force people out, based upon what they believe to be their own independent decision making, that's actually, that's so very untrue. If anything, they were just kind of showing them a certain piece of the overall, context involved in terms of the law, and letting these people choose to leave the U.S. And once they leave the U.S., depending upon their situation, they might not be able to come back for another 10 years or so. So that's been very frustrating. Seeing the F1 students, that the clients that I represent, being under attack. And then, kind of going back to the State Department, I suppose another area of surprise for me was the State Department choosing to reorganize their entire hierarchy. Secretary of State Marco Rubio, through whether it be government efficiency, he decided to consolidate certain departments within the overall, State Department. So as a result of that, what we anticipate is certain consulates closing, certain consulates, kind of limiting and restricting their, visa offices. And what's the trickle down effect of that? The trickle down effect of that is that it's going to be harder to secure a visa interview at whatever consulate that your foreign national worker is looking to apply to. And all of this is very fluid. We don't know the exact ramifications of this, but that's what we're expecting.
Okay.
Yeah,
Well, yeah.
if I could just
Sure.
add on to that, some of our higher ed clients experienced the same issue. That is, SEVIS terminated the student status in the database, causing all this flurry of worry and activity on the basis that now what is the ability on the part of the employer or the university to continue to employ this particular student, and can the student then continue to afford to pay tuition, etc. And so, notwithstanding, legal advice, wait a minute, it's in the courts.
Mm.
Give the court some time to rule on this. And as you probably know, then there was one judge who required Homeland Security to come in and articulate what the policy was, and they backed off. But in the meantime, you go back to the client. Good news, they've backed off. Client, bad news, they've left the country. Okay, it's
Yeah.
the intimidation and it's the impatience. Let's wait. These things are moving through the courts. Okay, there's no certainty. Just because there is agency action and an executive order, that does not translate into the law of the land. Let the judiciary figure it out.
All right. Well, as you said, it's these have been executive actions, and there's been a lot of litigation and a lot of challenges. I'd like to go into a little bit about now where he succeeded, where the president has succeeded, and where he's been thwarted. First of all, where he succeeded and what's changed. Leonard, from your perspective, put aside for the moment the fear and intimidation. I'm interested right now in talking about sort of the practical effects. What has stuck, as it were? I mean, the administration threw all of this stuff out there. What's sticking? What has it changed? And what does that mean for businesses?
Yeah, I think a lot of it's very fluid. I mean, there's a lot of litigation ongoing, which can change by the day.
Right.
But where he was probably more successful is some of the, humanitarian parole, TPS authorizations. A lot of that's in litigation. They had a recent win for TPS for Venezuela, which a court ruled that they're allowed to terminate the program. So there's so much back and forth, creating so much uncertainty. I get calls and emails every day from my employer saying, I've got somebody on TPS for Venezuela. They've got a work permit. Is it still valid, or did the date change? Did they get an automatic extension? So there's so much confusion because of the back and forth based on the court rulings. We've got the birthright citizenship at the Supreme Court now. So, a lot of it is just, is not sticking. But again, the problem is it creates havoc and uncertainty and confusion. Even though the administration probably knows there's not a good argument to make for some of these executive orders, but it just creates just confusion. Even for immigration attorneys, it's hard to keep up on all of the changes and what the state of the litigation is for the various visa programs. So, I mean, I think he's been very successful in creating chaos. But, long term, whether or not these executive actions or policy changes are going to stick, probably not, because they're probably not constitutional.
Right. Okay. And just so our viewers understand, TPS stands for temporary protected status. That's a way for folks who can stay here who may not be able to go back to where they came from. And there's been a lot of talk about that. But Min and Patrick, I want to get again your views on what is sticking now. Min, I'll start with you. What has changed, and what are you telling your clients has changed, and that they need to be concerned with right now?
Right. So I mean, I feel like Patrick covered, I'm sorry, Leonard covered, a lot of, I suppose, the direct challenges that are now, on appeal at the court level. And, with obviously the U.S. Supreme Court kind of ruling on the Venezuelan issue, we have, some closure regarding that in terms of work authorization. So, I mean, I suppose kind of secondary to that, though, like another thing that companies and employers should keep in mind is that there are different ways to kind of skin a cat. And, I think this administration is trying to be creative. And, there are immigration implications involved. And I suppose one recent example is, another Trump executive order that's seeking to change how universities are accredited. So, once again, going back to, the F1 student discussion, and this is, I suppose it's, I mean, we're kind of in the middle of H-1B cap season right now. H-1B cap for our audience is basically a fairly popularly used, work visa that U.S. employers seek to petition and sponsor for, certain high-skilled individuals who have at least a bachelor's degree in their, specific qualifying academic field of expertise. And as part of that, I don't want to go into the weeds too much regarding the program, but one of the things is that there's an additional 20,000 or so available work visas if someone graduates through, graduates with a U.S. master's degree from an accredited institution. But now that definition of accredited institution is now being revised. And I'm sure the administration has their, specific reasons why they're looking to kind of redefine what it means to be accredited and what those, organizations doing the accreditation, what they're all about. But I suppose, this is another secondary attack. It's not a direct attack of, let's say, removing TPS, saying that, these individuals are now free to go back to their home country, Venezuela, let's say. But there's also secondary ancillary things around the margins that the administration is doing, looking to just attack lawful immigration in general.
Okay. And Patrick, I mean, you, as Min said, you mentioned some of the court challenges. I'm curious where those challenges have been successful. I'm curious where the administration has succeeded in making the kinds of changes that they're talking about.
Well, one of the key issues before the Supreme Court, it'll be interesting to see in the next month or so, this issue of nationwide injunctions. Right. During the prior administrations, the idea that you would go into Texas to try to get an injunction against a Biden policy, that's where you would go. And you're pretty sure if you convince the judge, you'd probably get a nationwide injunction. Well, Trump has been successful in getting the Supreme Court to decide, apparently successful in getting the Supreme Court to decide on an expedited basis whether these judges who are issuing the nationwide injunctions, whether that is procedurally sound. And, as opposed to filing class actions, which, might have the same impact, but they take longer. So that's a success. So in other words, hey, look, the folks who are challenging, say, birthright citizenship, you may have gotten an injunction, but that injunction only applies in that district where the case was brought. Right. Some of the other areas, and again, the dust hasn't settled, but right. I've kind of ticked off about 8 areas that were on the Trump administration agenda where it's happening, requiring asylum seekers to wait in Mexico, expanding who's targeted for deportation, just beyond folks who are security risks, right. Expanding detention at the border, the travel bans. The courts made them cut back on the travel bans to ensure that they're not discriminating against Muslim countries, but those travel bans are in effect. Interagency information sharing. Everything is up for grabs now. FBI, USDOL, USCIS, IRS, they're sharing your information. Increased scrutiny of work permits. Expand the expedited removal. And then, as it appeared in the papers last week, challenging sanctuary jurisdictions. For instance, 4 cities in the state of New Jersey. Right. So he's implementing his agenda with some success. And like I said, the dust hasn't settled, but it's impressive and intimidating.
Okay. All right. So where though has the administration been stopped? And I know it's fluid. A lot of this stuff is still in litigation. A lot of these cases are still going through. But are there any areas where you can say, okay, the courts have put a stop to that, and we're not likely to see that again? Or are we still waiting for these things to be adjudicated finally by appeals courts and ultimately the Supreme Court? Leonard, have you seen anything to suggest that there have been instances where the administration is really going to have to give up on certain things, or is everything still up in the air?
I don't know that there's a hard stop on anything, especially in the employment-based area. But I think everything's still subject to challenge. I think, the whole TPS is most of the litigations involving the humanitarian parole. The foreign student visa terminations, they sort of reverse course on that. So I think there's just a lot yet to come, but I don't think that there are a lot of hard stops that the court has stepped in and said, no, you can't do this yet.
Okay. Min and Patrick, you feel the same way?
I do, I do. I mean, I suppose, I mean, time will tell. But maybe one word of advice and caution to, to employers is that, if there's certain issues that the administration has not yet focused on, because, I mean, obviously they're trying to, kind of throw like a pretty comprehensive blanket on a whole host of issues that
Right.
affect businesses here in the U.S. Um, and, but at the same time, because there's so many issues involved, they can only get to so many. And so we've been noticing that a lot of visa applications at the consulate, the State Department, Homeland Security, obviously, making it just more challenging for foreign nationals to exit and come back into the U.S. Obviously, those are high priority items for this current administration. Perhaps one issue that has been less of a focus, and perhaps this is where businesses can maybe use something to their advantage and kind of leverage, is that the Department of Labor, granted, the Labor Department has their own set of issues, a lot of them pertaining to adjudication delays for certain permanent residency applications, those initial labor certifications that companies have to file, but there hasn't been any kind of dramatic shift in the policy in
Okay.
how certain cases and how certain benefit applications are received. It's just that it just takes a long time. So I suppose maybe one piece of advice that I can offer is that if businesses are out there and they're kind of on the fence whether to sponsor permanent residency for a high valued, high net worth foreign national worker that they want to retain beyond the term of the work visa, I think now is the opportune time to really consider that before the Department of Labor sort of wakes up and says, oh, but by the way, we're going to kind of stand alongside our Department of Homeland Security and State Department brethren and make it challenging for U.S. businesses before they get to that point of making it more difficult to secure acceptable prevailing wages and all the other sorts of things that this administration was trying to push through 4 years back. I think businesses, they should really leverage this opportune time to kind of pursue those avenues before the Department of Labor actually, kind of makes a hard pivot in making it more challenging.
Okay. Well, Min, you actually anticipated one of the questions I was going to ask, and I'll put it to Patrick since I was going to go to him next. And that is there if all of this if all of these cases are still up in the air and it's still fluid and the dust hasn't settled, is there a window now to do the kind of thing that Min was just suggesting? Would you advise businesses to take advantage of the whatever has happened, whatever stays have been imposed, whatever injunctions have been issued to get done the kinds of things that they want to get done, or is that just going to create problems down the road?
Well, again, the fact that a number of these issues are in flux at this point should encourage business clients to take a little bit more risk. And that's the problem is why am I investing in a particular foreign national to work with my company when there are going to be so many speed bumps and barriers thrown up in the process and the fees. If you've taken a look at the big beautiful tax bill, so we've got new fees coming in. Buyer fees for asylum, work authorizations, temporary protected status, undocumented immigrants paroled into the country, $3,500 to sponsor an unaccompanied child. These are all, um, intended to encourage the American businesses not to proceed with these workers. So again, it comes down to on a cost benefit analysis, given the fact that the courts are stepping up to some of these issues, the clients may determine that, hey, look, it still makes good economic sense to sponsor this particular worker based on the need. And despite the inherent bias on the part of the government agencies, we want you to hire American. We don't want you to hire foreign nationals. Okay. That's what the businesses are concerned about. Am I going to get through the perm process? Am I going to be able to actually employ this person at the end of the process? And so I think the atmosphere is more conducive to taking those business risks than it was, say, February, March, when this slew of executive orders came out.
Okay. Well, Leonard, that actually brings up a good point too, and that is it still worth it for businesses to do this? I mean, my understanding of the process was that it was difficult, it was expensive, and it was time consuming before,
Yeah.
and now it's gotten even more difficult, more expensive, and more time consuming. And part of that, as Patrick suggests, may be kind of the point that the administration, that they don't want they want businesses to go through this. They want them to hire Americans. Is it still worth it for businesses to try to hire foreign nationals?
Yeah, and I think that goes to the whole argument, it counters the argument of the government that the only reason why an employer would hire a foreign worker is because it's cheap labor.
Right.
They can pay them a lower wage. They don't have to abide by the same terms and conditions and employment law. But there's no reason why any U.S. employer would ever hire a foreign worker unless they had to,
No.
unless they couldn't find the talent in the U.S. They couldn't the talent that they needed for this role was a foreign national. Otherwise, there's no financial incentive. It's 3 to 4 times more expensive to hire a foreign worker than a U.S. worker. We have prevailing wage requirements that only apply to foreign workers. A lot of times, those prevailing wages are much higher than what an employer would normally have to pay a U.S. worker. The legal fees, the government filing fees that keep increasing, it's thousands and thousands of dollars just in filing fees. So no employer in their right mind would ever just prefer to hire a foreign national unless they really had to. So that's really what the piece that's missing. There's a lot of rhetoric out there. You hear it from unions and trade organizations and the government and saying that, this is the motivation of employers so that they don't have to pay the same rate to a U.S. worker when it couldn't be further from the truth. And I think that's really what it comes down to. I mean, this administration, we saw in 2016 during Trump 1.0, buy American, hire American. So there were, that was an executive order that came out really making it much more difficult for an employer to hire a foreign worker over a U.S. worker. There were proposals to dramatically increase the wage rate that had to be paid by employers sponsoring foreign nationals. So it's that same culture. It's just repackaged into something new, but it's the same rhetoric that we hear over and over.
Okay. But and that sort of brings up the point of businesses aren't doing this because they want to. They're doing this because they have to. We saw that a lot in New Jersey, particularly during the pandemic, when businesses, for example, down the shore, couldn't get the foreign workers that they ordinarily would get. What does that mean now? I mean, if those workers don't exist, what do businesses do, Min? I mean, where do you go if the government is saying hire American and Americans are saying we don't want to do that? What do you tell your clients at that?
Well, I think this also it depends on the industry too. Where I see the most impact is in the lower skilled positions,
Right.
like our farm workers, our landscape laborers, dishwashers. U.S. workers don't want to shovel horse manure. That's not what we want to do. We don't want to wash dishes. We don't want to mow lawn. So who's going to do it? And that's part of the problem that, a lot of these seasonal businesses would not survive without foreign labor. They advertise. There's a required advertising component that goes to these visa requirements. They have to show that they couldn't find U.S. workers through newspaper ads. But they can't find them. So these businesses will likely shut down if they were unable to rely on some of these visa programs.
Okay. Min, you were nodding. I wanted to get you on this too.
Right, and even within the high skilled labor space, Leonard was talking about, I suppose, low skilled laborers, but even within the high skilled labor space, where we're talking about, cutting edge technology and basically folks within research and, just R&D in general. Businesses have been struggling to find appropriately qualified individuals, amongst the U.S. worker population. And to think that, the government is looking to artificially just kind of close off an entire pocket of eligible candidates for these businesses to thrive. Just not within, like, just kind of outside of like the fundamental fairness of that. It's just good business and good economy for companies to be able to choose and select whom to hire, whom to retain, and whom to just really kind of put their investment in order to make sure that these high skilled laborers are able to do what they're able to do.
Okay. All right. Now, you've all, I think, touched on the fear factor before, and I want to get a little bit into that too, because that's come up again in some of the other panel discussions we've had. We've had one on construction and development, and the folks on that panel were saying was already a problem, and this was a month ago or a month and a half ago, and all in our pre-Trump or Trump preview panel, the same thing came up that panelists were experts, business owners, executives were already hearing that people were afraid to come to work because they thought they were going to be arrested and deported. Patrick, are you hearing the same sorts of things? Is that a real thing? Let's talk first of all. Let's focus on
no
New
question
Jersey
about it.
because
No,
that's what we're talking about. So yeah, go ahead.
no question about it. We got a good example of an RFE, which is a request for evidence that the USCIS will send out. And in this particular case, we got a second request for evidence. And the only request made was, please reconfirm the beneficiary's residence address. Now, in the initial application, the residence address had been stated a minimum of a half a dozen times. Person is living in Bergen County. And now here's the USCIS saying, hey, by the way, can you tell us what his current address is? He was beside himself. What's going on? I said, look, when I show up for my interview, he had to go in for his biometrics. When I show up, am I going to be arrested? So again, what we had to do, take an ounce of precaution. We called USCIS and say, why are we getting this request for his residence? Because of course, everything in the newspaper, you go out on the sidewalk, you leave your safe zone, whether it's home or work, you're going to get picked up. And they're picking up people in courts. People who are responding to court notices are being picked up and detained. You're going to church. The church has been identified as a place where some illegal immigrants. You're going to get picked up. Oh yeah, it is a fear. And so it's up to counsel to try to identify what the fear is and try to identify whether it's real. Okay, am I and my wife about to be deported here? Mm-hmm. So no question. I just wanted to make a comment with respect to what do the clients do when the spout is shut off and they don't have the unskilled workers.
Okay.
It's everybody's, I'm sure, realized the irony that the administration wants to bring more manufacturing back to the United States. Again, that's pretty much the premise for these tariffs, right? Okay, who's going to do the work? How are we going to get the workers in some of these unskilled jobs in manufacturing? Where are these people going to come from, given the low birth rates? Nobody's really identified that back to the Trump administration.
Okay. That's a good point, and I will get to that in a bit too. But first, I want to get Leonard and Min on the fear and intimidation, because it seems to be, again, it seems to be part of the point of all of this is to make people uncomfortable, so uncomfortable that they don't want to stay here. Leonard, have you encountered that in your practice?
Even on LinkedIn, I see posts from immigration saying "leave now," in order to preserve your American dream. So there's social media posts by the government really promoting self-deportation, and so people are thinking, oh, that's a viable option, and I'm going to be able to come right back in after I leave the legal way. But they don't realize that if they've been here out of status, they probably triggered a 10-year bar from ever coming back or applying for a visa. So that's an issue. And we get calls from green card holders and people on valid visas that are terrified that they're going to be deported. Mm-hmm. So, I represent a lot of colleges and universities, and we've had webinars with their faculty on, travel specifically. A lot of them are nervous about traveling with social media posts. A lot of the faculty members in higher ed are very active in protests and hostile to some of the government actions and some of the wars. And so they're terrified that someone's going to see something that they have on their phone or a social media post, and they're going to be denied entry. And we see that with green card holders. U.S. citizens are even nervous in some cases. I mean, that's somewhat unfounded, but I think there's just that level of widespread panic and fear that people just are afraid to leave or do anything.
Okay, Min, widespread panic and fear in your experience?
Yeah, welcome to our profession. No, but I mean, like like I don't want to reiterate what Patrick and Leonard, kind of captured. I think they said it really well. But at the same time, it's one thing to just, kind of finger point the federal government saying, okay, like why are you doing this? And I mean, obviously, if the infraction is fairly egregious, then we have the courts to seek a remedy. But at the same time, like if this is the current state of affairs and this is the state of things, like what should employers do? Is this a good reality check for how companies, currently operate their immigration programs? So I know that one of the things that me and my esteemed panelists were talking about as we prepare for today's webinar is that it really is a prime opportunity for businesses in New Jersey to kind of revisit their compliance program. In terms of I-9s, if a company happens to employ let's say E3 or H1B1 or H1B employees, just how they maintain their public access files in support of those applications, just their overall compliance responsibility that businesses have when they hire and when they retain foreign nationals. It's super important. And I suppose we do have a change within within the regulations where before President Biden left office and Trump took over, there was that H-1B modernization rule that was implemented into law. And as part of that, there is an expansion of the just overall fraud detection National Security Directorate in terms of FDNS site visits. So I suppose it's a good reminder for businesses in the state to, if it's been a while since you actually kind of looked over your I-9s, conducted a comprehensive internal I-9 audit, or looked over your public access file records, now is a good time to do it because the federal government is on record saying that enforcement, compliance, those are going to be prime agenda items for the next 4 years. So it's a good wake-up call where these companies, employers should have been doing these things all along, and now it's a good reminder that the federal government is really taking employers to task. So before you receive a knock on your door by an ICE auditor, really kind of take the means and spend the time into kind of independently investigating to make sure that all your compliance paperwork is in order.
Okay, I want to get into that a little bit more with Patrick and Leonard, but before we do, I should just want to remind our viewers, or for those who joined late, that we are going to leave time for questions. If you want to pose a question to our experts, use the Q&A bar in the Zoom control button, the Q&A button in the Zoom control bar, post your question there, and we'll get to as many as we can. Okay, Min brought up the point of some of what businesses should be doing now, and I wanted to get into that because obviously there's a lot going on. I'm sure you're getting a lot of questions about from clients who either are interested or need to hire foreign nationals or have hired them and want to know what they can do to protect their investment. Patrick, what are you telling businesses now along the lines that Min just outlined? What should businesses be doing right now?
Well, in addition to the increased risk of an audit by any of the agencies authorized to audit an employer in its compliance with I-9, would continue to remind clients that lethargy or indolence with respect to pursuing the applications is going to come back and bite them. It's the processing times are getting longer. In some instances, the deadlines being imposed by the agencies are getting shorter. And so we remind our clients, look, there's a window open for pursuing this particular application at this point. And if you miss this window, for instance, if the H-1B visa is going to expire, or if the prevailing wage approval is about to expire, there are various expiration dates and or just the time period. It's onerous. It's so labor intensive going through the PERM process, which has been referred to the advertising and recruiting process. It's onerous and generally short, and you've got to hit it. You got to hit the nail right on the head. Otherwise, it can be rejected. And so we emphasized to the client, I said, look, you've got a tremendous investment in government fees, in the employee, and in legal fees. And so you have to get on this in order to keep prosecuting and pushing this application forward, or or else pretty much abandon it. And then of course the disappointment on the part of the client is, well, can you tell us what the cycle time is right now, say on the immigrant petition or on processing for the adjustment of status or any of these other applications that go before the Department of Labor? And they're not getting shorter. Some of them are status quo, but in many of them they are disappointingly getting longer by a number of months. And so that's what I'm telling the clients is, look, these things are not going to get any better than they are right now. So to the extent you were thinking, hey, look, it's going to be a slow dancing, it's like it's going to come back and backfire you on it if you wait too long to push this thing forward, especially if the client is interested in converting from a non-immigrant visa to an immigrant visa.
Okay, I want to get Leonard on this too, but Patrick, I'm just curious if you can tell me, maybe you can't. Given what we hear about what the administration's cutbacks, the mass layoffs and things like that, are you still dealing with the same people in these issues? You mentioned processing times. Are there fewer of them? Are they different, or is their attitude different? When you approach the agencies, what are you hearing?
Well, it's very rare that you actually know who's processing. Although there is one particular person we were able to kind of research as far as why this USCIS agent was giving our client such a hard time. And we found out that she was a very highly recognized and rewarded USCIS agent for doing exactly what she was doing to our client. So that was the exception. But many of these letters come back with some kind of a code at the bottom of the letter indicating it's agent XYZ or something like that. But, for instance, the I-140, that's the application for immigrant status. It's, you go to the Texas Service Center, 9.5 months. Nebraska Service Center, 7.5 months. If you go EB2A, 12.5 months. Nebraska, 6.5 months. These periods of time are very disappointing to clients. But they're not going to get shorter. So that's just kind of a taste as to what the processing time is just for one step. And usually these applications to convert from non-immigrant to immigrant status consume 4 different steps. This is just one of the steps. So, by the time it's all over, the various people at the client who authorized this are no longer around. And they turn to the lawyer and say, would you kind of fill me in as far as why we thought this person was so necessary that we spent all this time with this person? So that's a continuing investment as well, reminding the client this is why this person's so necessary, and reminding the client is you're very much tempted to continue to change the job description for this person over the 2 or 3 years it's taken, but you can't. Okay. You can't change that job description. That's a constant tension that the client is saying, well, why can't I? I said, because you've already certified that that's the job you're going to be offering this person. And that's another consequence of the period of time that these applications take.
Okay. So Leonard, what would you tell a business who, as we just said, wants to protect their investment, or maybe they don't have foreign nationals now, but did in the past, and sort of have the picture of what the process was like then in the past. What do you tell them now? What should they be doing now?
Yeah, I think one of my most difficult jobs is managing expectations of our clients, because especially ones that have lived through prior administrations where we were getting approvals in a matter of months, and then now we're seeing enormous delays and backlogs. So, and the problem with managing the expectations is it changes constantly. So, clients remember the first thing that you told them, oh, it's going to take 2 years. And then 6 months later, we're up to 3 or 4 years. So it's just very difficult. And I've stopped estimating right now. I don't like to give an estimated processing time because we just don't know. And there's so many variables. So, all we can do is tell the employer, look, you're in for a roller coaster ride. There's no way to predict this. We don't know exactly how long it's going to take. We're confident that it's going to be successful, but we don't know how long that's going to take. And so the employer then has to weigh whether or not it's worth it the timeline, and then the cost. And employers don't have to sponsor anybody for a visa or a green card if they don't want to. So one of the things that we work with employers on is coming up with an immigration policy to begin with. What is your policy? Are you going to sponsor? Are you not? At what point are you going to sponsor? What types of visas or positions would you sponsor? So all of that needs to be thought about probably much earlier before they engage in a process. And if they are sponsoring, can they recoup any of the cost for these visa processes or green card processes in the event that the employee ends up leaving or their visa is denied? And a lot of non-immigrant work visas, like the H-1B, is an employer expense. So that's a business expense that the employer cannot get back or have the employee pay them back for. Certain stages of the green card process, they have a little more flexibility to recoup some of that investment. But a lot of my clients have a sponsorship agreement where it says, all right, we're going to sponsor you for a green card, but you have to stay with us for 3 years after it's approved, or you have to pay us back the allowable costs under the law. So a lot of times that's a tool that employers can use to sort of get sort of recoup the investment that they've made. We've never tested some of these in court, so we don't know how a court would look at it, and it does depend on the state whether that's an enforceable contract. But a lot of employers do it as a deterrent so that the employee understands the investment that's being made, and they hope that by having them sign an agreement, they actually stay, even though it may or may not be enforceable.
Okay. Right. Just to remind our viewers, we are getting close to the top of the hour. We are going to get to your questions. But before we do, there are a couple more things I wanted to get our panelists to weigh in on. The first is we've mentioned sanctuary cities and the challenges to the 4 cities in New Jersey that are subject to a lawsuit. And generally speaking, the public officials here, for the most part, especially in the cities, have not been receptive to the kinds of things that the federal government wants to do. Can businesses count on that? Is there anything that they can look to the state or local or municipalities to help them with in this regard? At least right now. I mean, Patrick, what do you tell folks who say, well, this is New Jersey, they can't do that? I mean, we're a state of immigrants. Everybody knows that.
Look, I think everybody pretty much knows where the Republican strongholds in the state of New Jersey are and where the Democratic strongholds are. And I think it's going to break down along partisan lines. It's I would expect I would expect the constabulary in my hometown in Somerset County to be fully cooperative with the Trump administration. As we've seen in the papers, the administration here in the city of Newark, not so much.
Right.
Okay. So I think it's going to break down in partisan lines, and as a result, we're going to see litigation, and they're going to fight it out. And I think and Murphy has gone on record indicating that New Jersey is a sanctuary state. Now, whether his attorney general is going to step in the middle of the litigation remains to be seen. But it's no easy answer, and I don't think that there's going to be a unified voice within the state of New Jersey. I think it's going to be breakdown along partisan lines, depending upon Democratic and Republican strongholds.
Is that the way you see it too, Min? There's really the state. It's going to vary town to town, and the state may ultimately not be able to help that much.
Right. It's the uniform front. I think it's a pipe dream. Unfortunately, it is gonna kind of be divided along partisan lines, and I suppose just a larger point regarding expectations. I just kind of want to circle back to what Leonard touched on before, and I think this is just whether we're talking about sanctuary cities or just expectations in general that foreign national clients have or businesses have when looking to kind of sponsor foreign national employees for work. I think expectations are pretty critical, and hopefully businesses have trusted partners, legal partners, who don't just kind of spew whatever the companies want to hear, but they're kind of realistic and measured in their approach. And it really is an opportune time, I believe, for employers in the state, even if they have already an established immigration program, where let's say that after so many number of years, if things go well, then the company chooses to sponsor permanent residency for so and so individuals. I think these past few months have shown us, and Trump 1.0 has shown us that it really might be an opportune time to kind of revisit any kind of predetermined, preconceived policies that businesses might have. What I mean by that is, let's say if a company was if their historical practices have always been, we only have the discussion with the foreign national to sponsor permanent residency after 3 years of work or 4 years of work. My panelists I mentioned before, we're just dealing with more increased fees, more lengthy processing times. So like that, that marker, that target is always shifting. It's going to cost businesses more to continue to sponsor, short-term work permits for the foreign nationals. And, it might very well be that the entire permanent residency process cannot be completed because before, let's say a labor certification was adjudicated in 7 months, now it's being adjudicated in 17 months. So these are the expectations that, hopefully a lot of companies, they can kind of go to someone that they trust, who's realistic with, the things that this federal government is looking to impose on businesses, and have a really realist have a real conversation with, maybe our policy before it made sense for our enterprise 5, 6, 7 years ago, but in this current climate of immigration enforcement where everything is being challenged by at the federal government level, it might be a good time to kind of revisit those programs.
Okay. All right. We are going to get to questions. There's just one more thing I wanted to get to before that, and that is just the outlook for the future. I'm curious as to all three of you what you think is going to what you think might happen beyond when we get past this sort of initial flurry of executive orders and challenges. I'm guessing that you're not expecting too much out of the current Congress, but would you look to Congress in a future Congress to try and finally tackle comprehensive immigration reform, something that they've been unwilling to do up until now? Leonard, what do you tell clients who say, is this we have 4 years of this at least that we have to go through, or do you tell them that there may be hope somewhere down the road?
I mean, I think Congress had the opportunity for many, many, many years to fix the issues, and it hasn't happened. And I just think immigration's one of the most polarizing topics, and I don't know that it's possible to have an agreement between both sides. I think there has to be give and take, but it seems to be one of the hardest things for Congress to do is to agree on an immigration policy, whether it's a culture of enforcement, whether it's allowing a legal pathway for additional people to come. But it seems to be an impossible feat. So I'm not optimistic. Maybe I'm just jaded. I don't know, but I'm not optimistic that there's going to be substantial change. And what we're probably going to see are these patchwork provisions, band-aid provisions that kind of get us by. And what we can expect are additional challenges. Everything's just going to be harder. Even for our routine visa applications, we're seeing requests for evidence, additional challenges. We're seeing delays at the U.S. consulates and workers applying for visas. Just the other day, the Administration Department of State just said they're pausing all new visa appointments for foreign students and J1s, and that's a critical problem, especially for J1s, because we have thousands and thousands of medical residents and fellows coming in every year on the J1 program. All of our hospitals and are relying on these individuals coming in. 1 out of 5 physicians in the U.S. are foreign born, and a lot of them were on the J1 program. So things shift constantly, and it's just evolving every day.
Okay. Patrick and anything to add on that in terms of what we can expect in the future and what businesses can do? Because making policy by litigation doesn't seem like an ideal way to run a business or a country. So
it's kind of like the watch on the Mets right fielder. Okay, how come he hasn't hit more home runs? Hey, look, this administration is just getting started, right? They're 4 months into a 4-year term.
Mm-hmm.
I don't think we've seen everything yet. They're still trying to get all of their folks appointed after Musk has left town, and trying to kind of put some of their pay back some of their political favors by providing folks in some of these enforcement agencies who are willing to do the president's administrative tasks. But you know, to the point of what about Congress? We got to keep our eye on Congress because Johnson is, he was able to maneuver the tax bill through. There was a bill introduced March 25, HR 2315. And if enacted, this, and it was obviously introduced into the House, it would eliminate OPT. And so that strikes right to the heart of the whole idea of we're educating international students in American universities and using some American facilities to do that. And yet we are cutting these international students off at the knees. We're not allowing them to pursue optional training if this particular bill is enacted. And so it's not out of the not out of the possible that that Johnson can maneuver some of these bills to being passed both in the House and in the Senate. So Congress needs to be watched. But I agree with Leonard. I don't see any comprehensive immigration legislation coming down the pike in my lifetime anyway. I intend to live quite a few more years.
Okay, well, we all hope that's true. Min,
Thank
do you have anything to add on that, or do we?
Right. I think comprehensive immigration reform. I mean, and it's been kind of bandied about here or there. I agree with my other panelists that maybe there was a time so many years back where perhaps some serious discussion could have been had. I don't think anything within the next 4 years is imminent there. It really is just kind of an ad hoc, a patchwork remedial effort.
Right.
That a lot of businesses and foreign nationals can sort of expect. I suppose maybe the one thing that I'll add is that on a biannual basis, the government agencies, they do kind of publicly release their specific high priority agenda items. So I suppose that's the patchwork cures that that I'm referencing. You can not to say that they always stick to those timelines, but on a given year, on a given season, whether it be leadership at Homeland Security or Department of State or Department of Labor, they release saying that on a given year, 2025, 2026 and beyond, they're going to look to promulgate rules that make these changes. So if businesses want to be kind of on the forefront and expect, it seems like the federal government is going to be pivoting in this fashion or that, rather than looking to Congress or maybe even like the courts, just kind of focusing on those regulatory priority items at the agency level, it really kind of provides a pragmatic approach so that businesses are not unduly surprised.
Okay. All right. All right. We do have some questions. I'd like to get to those. The first one, I'm going to pick up right where Patrick left off, because the question on the new policy of what's the new policy of OPT graduates, that's optional practical training graduates, to legally work in the U.S. You mentioned the bill, Patrick, but has anything changed up before that?
Here's the update. It's been referred to the House Committee on the Judiciary. So that's where it is now. It's still in the House.
All right. So, but the policy at this point has not changed as far as?
Oh, no, the policy has not changed. So, yeah, OPT is still there. And then there's STEM OPT as well for students who are eligible and have studied in the STEM world. So that's still status quo.
Okay. All right. Moving on, I wanted to ask this question because I wanted to get in. I wanted to cover some of what's happening in some of the industries. This question is specifically about the construction industry, and estimates are that up to 7.5% of construction labor is affected. I'm not sure if any of you have a lot of experience with the construction industry. If so, let us know what you think about that. Patrick, you're nodding, so I'll ask you what you can tell us.
Yeah, the experience is not positive. The experience is a lot of I-9 violations. Okay, and then when you go to challenge the violations, there are various mitigating and exacerbating criteria that the judge takes into consideration. And when an employer, and the employer I'm thinking about right now, construction employer, had close to 200 employees. Essentially, the judge said, "You're really not in the position of being able for me to give you any kind of any mitigating circumstances here, because you employed so many people, you had no I-9 compliance process, and you've employed them for such an extended period of time with no effort to recruit American workers. So my experience, it was a very expensive one for the client in the construction industry.
Okay. All right. And Leonard and Min, I wonder if you can talk about some other industries. Particularly interested in healthcare, pharmaceuticals, and technology, since critical to New Jersey's economy. I talked recently with Bob Garrett, who's the CEO of Hackensack Meridian Health. They have a partnership with one of the largest health systems in India right now, to have nurses help out virtually at their facilities in New Jersey, but they hope eventually to be able to bring them over here. What's the outlook for those kinds of things? Let's talk about healthcare and pharmaceuticals and technology in specific. Do either of you have any sense for how those industries are being affected, and what those kinds of companies can do? Leonard, I'll start with you if you have.
Yeah, so for healthcare, it's a chronic issue because we clearly have shortages of physicians, nurses, and med tech. So a lot of my clients have very robust immigration sponsorship programs for all of those. Recently, specifically with RNs have always been a challenge because when we talk about work visas, we always look at the H-1B visa, which is our most popular work visa. And that visa it's only for positions that require at least a bachelor's degree. And the issue with RNs is that it's not a firm requirement to have a bachelor's degree. We see a lot of associates level RNs. So immigration has traditionally challenged those roles as not qualifying for an H-1B. There's been a series of policy changes and guidance over the years, which make it more of an option. So right now we have a very large RN H-1B programs for our healthcare clients. And it's important to show that these are higher level nurses, they're emergency room nurses, critical care nurses, ICU, and that therefore they need a higher level of education. So, if the RN has a bachelor's degree, then we're able to get an H-1B visa. So we see that. There's also special green card programs for RNs. But we're doing hundreds and hundreds of these just because there's such a demand here that we don't have enough U.S. educated nurses to fill all of these open roles. So that's always been a challenge. Thankfully, right now, we're anticipating some more challenges on some of these, but we haven't seen it. We've gotten, one request for evidence for one of the cases. We were able to resolve that. So we haven't seen a large shift for healthcare yet anyway, and any disastrous outcomes.
Okay.
And I can speak, on behalf of technology. I suppose maybe one thing that employers within the technology space can kind of keep in mind is that, and I'm sure this is prevalent in other occupations as well, in other verticals, but some technology-based positions, there's been a reclassification of how the Department of Labor kind of views certain jobs. So there's I don't want to get into the technicalities too much, but if we're talking about certain jobs being classified as job zone 1, 2, 3, 4, 5, perhaps some occupations that were kind of slotted under a higher criteria, let's say a job zone 4, have now been bumped down to a job zone 3. And the reason why I mentioned that is that it goes back to what's categorized as is this considered a specialty occupation for H-1B purposes? Is a bachelor's degree required for entry into this profession? If there might be an argument otherwise saying that before as recent as last year when this job was quote unquote a job zone 4 job, maybe it was indisputable that it was, but now it's bumped down to a job zone 3. So I suppose those are the issues that a lot of technology employers have to deal with. They have to be agile and responsive to how the Labor Department views certain occupations within their space. And it also impacts, obviously prevailing wage levels as well. If a certain job under job zone 4 commanded X dollars in terms of a minimum prevailing wage, now it's a job zone 3, and now it commands a certain Y dollars, something that's different from what it was a year ago. And I empathize, and I empathize with employers because obviously they're trying to strategically plan long term. And now they're hearing from me that, you said before this time last year that I can pay my worker a certain amount. Now you're saying that I have to pay this particular worker another certain amount. This is no way to do a business. Like, why does my company have to just pivot back and forth here or there? But unfortunately, that's what we deal with. It really is kind of at the hem and haw of the Department of Labor Agency in terms of job
Right.
classification, as well as certain prevailing wage levels. And maybe one other thing that I can add for technology
Sure.
based companies is that just kind of moving away from the work visa space. If a certain valued employee wants to be sponsored for a permanent residency, uh, there are other agencies besides, we spoke a lot about the State Department, Homeland Security, and Department of Labor. But there are obviously other agencies such as the Department of Justice. Just a few years back, specifically when it comes to perm labor certification, two very notorious cases, a Facebook case and the Apple case. It's We're still kind of, you know, kind of um, we still have the ripple effects from how those two settlements came to a resolution. It's basically a reminder for all employers who are looking to sponsor a labor certification for their foreign national worker population. It really has to mimic the traditional historic recruitment practices that they've engaged in when it comes to hiring U.S. workers. Just because a specific opportunity might be, classified a perm job, it doesn't mean that, you can depart from how you traditionally advertise a certain job, recruited for a certain job, as, my panelist has spoken about before. So that's another reminder saying that, don't just think that, I just have to make sure that I comply with Labor Department regulations, Homeland Security. There are other agencies that are involved that want to get into this immigration space.
Okay. All right. Okay, let's see. We have a couple of questions about recourse. First of all, for an electrical engineer, is there a hardship? Can an employer argue that it's a hardship if an employee was to be deported? How's that going to go over?
Well, is the hardship here in the United States or is the hardship back in the home country?
I would guess that it's a hardship to the employer, so it must be here in the United States.
Yeah, yeah. Look,
No.
we've used the hardship argument in connection with attempting to get an expedited determination from the agency, but I've never had to explore a hardship for the person's being deported. Usually where hardship comes up is in my practice is cancellation of removal. That is the person would experience and family members would experience hardship if the person were to be deported, removed from the United States. So in that situation, hardship is crucial in,
Okay.
in in demonstrating that there would be a hardship visited on the alien as well as family members, especially if the family members are United States citizens and are not deportable.
Okay. Yeah, I mean,
Right.
this is all hardship, right, Min? I mean, everything we've talked about is a hardship to employers at this point.
Right. I mean, it kind of brings me back to,
And I don't mean to make light of this. This obviously this is important to this company, and I don't mean to make light of the question, but
of
I mean,
course, of
yeah,
course. Yeah, and like Patrick referenced it, but it kind of brings me back to, obviously it's a different state of things now compared to when, the COVID pandemic was happening and, everything that was going on there. I suppose, there was one solution in terms of expediting a visa appointment, and perhaps a company was able to kind of cite, quote unquote, business hardship in order to make sure that the person was able to secure their visa to come back to the U.S. and continue work, as proposed. But that's a very isolated set of facts.
okay,
Obviously the world was a different place, at that time. But yes, just generally speaking, I don't know. Perhaps my other panelists might see otherwise. But when it comes to just business related hardships, that's not a point of empathy or sympathy on the part of the
right,
government. It really has
Hmm.
to go at the personal relation level when it comes to a U.S. qualifying spouse or a child being separated from their foreign national parent or husband or wife. Those are the strained hardships that immigration might be responsive to, and even given that it might not be good enough.
okay, right. And the second question along those lines: if I am a J1 student, and my employer wants to fire me because I cannot work on Saturdays, what can I do? I'm assuming the employer is the school where the person is a student, and I would just broaden it out to say, is there what is the what's the outlook for challenges based on what in other contexts might be considered? And I'm assuming this is a religious objection to working on Saturdays. What's the outlook for challenges based on what in other contexts would be considered constitutionally protected activities? Does that enter into these calculations at all?
If that worker is working in the United States, then that worker is covered by civil rights laws.
Okay.
Okay. And so then to the extent that that employee feels he or she has a claim of religious discrimination, then it's actionable. For instance, it's actionable under the New Jersey law against discrimination,
Sure.
and it's actionable under Title VII of the Civil Rights Act.
Okay.
And notwithstanding what Attorney General Bondi has said about disparate impact, it's still actionable.
Okay. All right. We have a question from a viewer on, are there any countries that this administration is giving a pass to? Leonard, have you heard anything about that? I mean, we know, for example, that they've singled out Afrikaners in South Africa for coming over here. Are there any other examples where the administration says, you want to hire somebody from Sweden, go right ahead, but
Not yet, but that's probably coming. South
Okay.
Africa is the only one that sort of has this special program now
Right.
where, you're able to fill out a form online and come over to the US. But historically we haven't seen that really. We have free trade agreements with certain countries that allow for additional visa options. Like we have Australia has a special visa program, Singapore, Chile, that have special work visa programs apart from the normal H-1B. So we've seen some countries, but there's always been more of a free trade agreement negotiation contract in place. This is something that we necessarily haven't really seen much of.
Yeah, the one that comes to mind may not be what the questioner is asking about is ESTA. That allows it's an expedited way of getting to the United States in lieu of a B1 visa. Okay, and that's ESTA. But that assumes that the worker will have no U.S. source income. Again, it's pretty much equivalent to the B1. But it's an expedited way for, say, in my experience, European workers to come over to the United States, catch a couple of business meetings, and leave.
Okay. Okay. We have a question about someone asking, who can we contact to advocate for our needs? I'm assuming, first of all, one of you three. But I think this goes beyond just sort of hiring a lawyer. Are there, and one of you, I think Patrick may have mentioned organizations, and we've already talked about sanctuary cities. Is there anybody out there that folks can turn to? Let's keep it on businesses and employers can turn to for help and with sort of navigating the system and what they need to do, short of hiring one of you three.
Well, I see that the ACLU is a named plaintiff in a number of these cases, so that's one particular option that should be considered.
Okay. All right. Yeah, and I'm again, it's really you really need legal counsel. I'm thinking for a lot of this. So
yeah.
Yeah. All right.
Yeah. If you're going to bring a federal court case, which is where you're going to be, you don't want to be dismissed on day 2.
Right.
Yeah. You want to make sure you've got your jurisdictional requirements set.
Right. Right. If you're going to make a federal case out of it, you should have someone who knows what federal cases are. Okay, we are almost out of time, and I want to give you each a chance to offer some final thoughts. But before we do it, there's one more question. Are there any discussions within the administration focused on improving services within the immigration system? Have you heard any of that? I haven't. Mostly what they're doing is cutting back. Even though as we've said, that they're making the system more cumbersome, they're not really putting in. It doesn't sound like they're hiring people who have the kind of expertise necessary. Min, have you heard anything like that?
Right. I suppose my mind immediately goes to. It was a trial period, and all bets are off whether this government's going to kind of re-up that effort. But stateside visa processing.
Okay.
It was like that before 9/11, but I suppose in response to the terrorist attacks, as the foreign nationals who might be in attendance kind of know, a lot of times now, if you are not visa exempt, you have to secure a visa at a consulate abroad. So there was a short window where the Department of State was amenable to kind of bringing back stateside visa processing, meaning that the application, you don't have to step outside the U.S. borders. You can send in your application directly to DC and have them process the application. Once again, it was a trial run. It was just reserved for H-1B employees, a very limited number of eligible individuals as well. So, I haven't heard word whether that's going to be a priority item for the Department of State, but I suppose that's kind of forefront in my mind. It definitely helps. It relieves government burdens. Obviously, it takes a considerable expense for the State Department to fund those consular posts and embassies worldwide. To think that we can have a centralized source where we send something to DC and the visa can be renewed and mailed back to the applicant, that's going to be tremendous. So, fingers crossed that hopefully, this government sees the benefits of that. And knowing that it can't be provided across the board, obviously, someone who does not have any kind of adverse history, criminal, or anything of that sort, any kind of previous immigration violations before, only those population groups should be eligible for this recourse. But provided that they are, there really is no need. I mean, there really is no reason I can think of where, whether it be the government or businesses or foreign national workers can't benefit from that.
Okay. All right. Well, we are almost out of time, but I do want to give you each a chance to sort of sum up or mention something that you haven't sent before. I'll start with this time. We'll start with Patrick, and we'll go in the opposite direction.
Yeah, let's just keep in mind that Stephen Miller, who is the Trump boy genius on the immigration issue, he's a holdover from Trump 1.1. He's made it clear. He said, we're looking to set a goal of a minimum of 3,000 arrests for ICE every day. And we know that some of these folks who are being arrested are U.S. citizens, and they're being deported. And the Supreme Court is telling the administration, you've got to facilitate the return of this person. And now the Attorney General is quibbling as far as what facilitate means.
Right.
Okay, so we're going to have more of this. It's going to be stretching the law in order to make it much more difficult than it is right now to hire non-American workers. Okay, as long as we understand that, everything else makes sense. Back to the earlier point, is there anything that helps? I think the most helpful thing, but again, it's an expense item, premium processing. A lot of our clients are, in order to get out of the quagmire of delay, ante up I think it's the $2,800 or something to have certain of the applications before USCIS premium processed, which generally guarantees that the application will be looked at within 15 business days. So that is, I think if the government does away with premium processing, that's another bad sign. Okay.
All right. Min, final thoughts from you?
Right. I mean, perhaps just a couple of takeaway points. Maybe first for the foreign national non-citizens who might be kind of viewing this. Make sure you have your paperwork on your person at all times. And kind of circling back to what kind of what Patrick referenced right now. ICE agents, and they have specific directives of removing so many thousand number of non-citizens, and in order to combat that, make sure that you have your valid documentation, your I-94, proof saying that you are authorized here until so and so date. If your EAD reliant employment authorization document, if you're EAD reliant and you use that document for work purposes, make sure you have those originals on you. Yes, it can be cumbersome to to carry all that paperwork, but it's always best to err on the side of caution. We typically reserve that advice for folks who are traveling internationally, because obviously at the port of entry they're going to be stopped by CBP and investigated to make sure that they have the lawful paperwork to come to the U.S. But even if you're just kind of driving to church or to the grocery store, nowadays it's always best to have that paperwork on you, because you don't know when or who an ICE agent is and when you're going to be stopped. Just because unfortunately you might be quote unquote foreign looking, and that might be enough for an agent to kind of motion you over and kind of ask to see, so what are you doing? Why are you working? How are you working? In order to produce that right there on the spot, obviously it will definitely be, easier for you and your family. And I suppose, when it comes to the businesses, kind of sponsoring, those companies sponsoring foreign national employees, just kind of circling to my earlier point, it really is a good time, I believe now, to kind of take a look at your compliance programs, your I-9s, if you're an E-Verify employer, making sure your E-Verify reports. Be mindful that certain things do not have to be retained from now into perpetuity. There is a purging option. If you fall within that window where your I-9 no longer needs to be retained, there's no reason for you to retain it if the employee is no longer with you, provided that you retain it for the required specified amount of time. So instead of relying on doing that audit work and the compliance review internally, it's always beneficial to look outside your walls, your company walls, and hire like a fresh set of eyes, whether it be an employment immigration lawyer that you trust, or maybe some other company, where they can look at the I-9s and the public access files and all those compliance paperwork that you're required to retain, and perhaps maybe the people that you trusted internally within the company, they thought one thing, but it actually turned out to be untrue. And then, perhaps an independent investigator will be able to kind of point out, these are the things that you can improve on. Because, knowing how much a violation of I-9, I think an I-9 violation is like $2,700, $2,800. It can go up to that amount per I-9 violation. And if you're a company that employs hundreds and thousands of employees, odds are that, there's going to be I-9 mishaps here or there. So it really is an opportune time to kind of investigate that and really explore a way to kind of improve your compliance agenda.
Okay, good points. Leonard, that means you get the final word.
All right. Yeah, I have to agree with what was said. I mean, we're living in an era of unprecedented enforcement, and I think specifically on the employer side. I mean, after ICE comes after all of the individuals that are here illegally, that are easily identified, they have criminal backgrounds, order of deportation, where are they going to go next to achieve these numbers? They're going to go to employers, and they're going to do that through I-9 audits and wage and hour investigations. So, I'm doing a ton of I-9 audits right now, and I think employers are getting scared straight because they're seeing what's going on. So it's look at your records, and not only looking at your I-9s for errors, but also to identify any questionable employees, or that may be in a vulnerable status, or that there may be an issue with their paperwork. Because when ICE comes to do this investigation, ultimately, if they find that someone's unauthorized to work, they're going to have to be terminated, or they're probably going to be taken into custody. So what impact is that going to have on the employer? And certain industries are more vulnerable. Agriculture, like I said, a lot of them, have questionable status. So what's going to happen when 60 employees automatically disappear for those operations? So we're recommending that they start thinking about that now. How are they going to fill these open positions, which are already hard to fill? It's on the professional end, it's on the lower skilled end, but everybody needs an I-9, and so that's where you have to start. Also, given depending on the industry, you want to have a rapid response plan. If you get a government visit, whether it's wage and hour, whether it's ICE, what's your plan going to be, and how you're going to deal with that visit? Train your employees and staff on how to handle a government investigation or government visit, just so that you have a plan in place before it happens.
All right, very good. All good points. This is an important and timely discussion. Thank you to all of our panelists. As always, viewers, you can read coverage of today's event later on njbiz.com, and we'll have expanded coverage in an upcoming print edition, which will be dated June 9th. And remember to look for the recording link. Thanks for watching. Until next time, stay safe, everyone.